Under the government's interpretation of subsection A6, the task force members are still principal officers because they have unreviewable discretion when deciding not to recommend A or B ratings on a particular preventive care service, or when they decide to withdraw a previous A or B rating that they have conferred prior to their decision to withdraw. That means they have final decision-making authority that's not subject to direction and supervision. The second,
I'm sorry, I don't understand that. Can you help?
Yes.
What do you mean? They have unreviewable authority? First of all, I thought there was an interval period that the statute imposed.
That's right.
What function is that if not to have some consideration of what these recommendations are? That's one question.
Sure.
And then another is what do you mean about them having unreviewable discretion not to make a recommendation?
So the test for principal officer status is whether the officer in question is directed and supervised in his decision making. On the government's reading of section 299B-4A6, if the court were to adopt that view, the secretary would have the ability to overrule task force decisions to confer A or B ratings on preventive care. But the secretary would not have any authority to overrule the task force.
But why is that? Why is that? I mean, they make a recommendation and they have rejected other recommendations or other options. The secretary puts into place the interval period, reviews what they did and didn't do, and says, I'm going to remove you. As a result, I don't like what you did or didn't do, and you're out.
That doesn't make them into inferior officers, and Arthrex holds as much, because Arthrex acknowledges situations in which a principal officer can, through informal means, influence the decision-making of a subordinate official. And Arthrex says that's still not good enough. There has to be a formal authority to review the decisions that are being made.
But what about all the adjudicatory cases? Mr. Mupon says this is more like Edmonds. This is independent in the sense that people are making recommendations using their own best judgment, but they're still at-will removable, and we found that is okay.
But they also have all their decisions subject to review by a principal officer. What this court said in Edmond was that the reason those judges were deemed inferior was because they could not issue any final decision on behalf of the United States without being allowed to do so by a principal officer.
Mr. Mitchell, I take